Good afternoon. Welcome to the Law&Crime Network. I'm Misty Marris, and today we have a big day here on Law&Crime. We have two cases. We are waiting and watching for a verdict. We also have the Kellen Winslow case. That case, closing arguments are expected soon. Okay, we're watching the prosecution's closing arguments in the Kellen Winslow case. I want to break this down a little bit with Katherine Smith, trial attorney. Now, let's talk a little bit about what we're hearing from the prosecution. Not too much surprise that there's a focus on the similarity between some of the allegations, the similarity between some of the testimony of the victims here. What do you make of this closing as of this moment? I mean, there's more to come, but what do you think so far?
I like that because, listen, it's when you have these disparate acts and disparate incidents, you need to have some sort of connective tissue. You don't have to, but it really helps. And I think the drawing out the commonalities in all these women who are unrelated, who have never met each other before, was a good technique by the prosecution.
Yeah, and what we also heard from the prosecution was the statement that he was predisposed to this type of sexual violence. Do you think that was an important point as well? I was thinking more about the propensity. I'm thinking more about the fact that, lightning doesn't strike this many times. You have this many allegations against one person. Use your common sense a little bit, jury, and that's what he was going for. But he was talking about this predisposed nature towards sexual violence. What did you make of that?
Yeah, I wasn't expecting that, to be honest with you, because, I haven't seen every single piece of testimony, but what I have seen, and I've seen a lot of it, I didn't see any evidence about predisposition. What I do think is this propensity. The idea, like you said, with the lightning striking twice, but this idea, well, you have to say that all of these people are lying.
Right.
Every single one of them. And it's not just that we have a situation here where where he's denying every sexual contact. It's, well, when there's DNA, it was consensual. And when there's no DNA, it never happened. And I mean, come on.
Yeah, Katherine, there's going to be a lot more to break down. Tough road for a defense attorney without testimony by their client to say that it was consensual. But we'll see what the jury thinks. We're live in the Winslow courtroom with the prosecutor's closing arguments. I want to bring Katherine back in to talk a little bit about this. Now, in this part of the close, we heard a lot of focus by the prosecutor on the fact that just because there isn't a struggle, there aren't signs of a struggle, there isn't testimony about a struggle, that doesn't necessarily mean there was consent. Do you think this was an important point to make?
I do. It's sadly old school, right? A lot of people think of rape and it's like, well, if you didn't fight back, that meant you must have consented. And we know that that's not true. But clearly the prosecutor is hinging on some anticipated argument by the defense, or maybe even he gauged the way the jury is reacting to some of that testimony from the victim. So he's putting out there, listen, you don't have to be screaming for bloody murder. You don't have to be putting up a physical fight for there to be lack of consent and for there to be rape.
Right, and we saw that he had charts, he was showing the elements of the statute saying you don't have to run, you don't have to, you don't have to have this big full-out brawl to try and escape. It can still be rape. That's certainly a point that's going to matter a lot as the jury begins to deliberate this case. This is the prosecution's closing argument in the Winslow case. I want to bring Katherine back in to break some of this down. So first of all, something that really struck me was how the prosecutor was focused on addressing the demeanor of each of the victims, that during their testimony, although all alleged victims acted very differently on the stand. What did you make of that?
I like that because, we actually off air were talking about how some of the victims came across. For example, even he referred to Jane Doe 1 as being a little bit more flat and less affected, right? I think the idea of that is showing that we don't need to expect a consistent reaction from all the victims such that it all is true. You don't have to be crying. You don't have to be outraged. People react to trauma in different ways.
Right, that there's not this one cookie cutter response that's going to be the same for each victim. I think that was also a very effective point. Something else that struck me, and we talked about this a little bit before we came back on air, is the focus on the consent issue. Again, we see the prosecutor looping back to this, making the point that there was no evidence of consent presented by the defense, but he's the one with the burden of proof.
Exactly. He actually pointed that out to the jury. He bears the burden of proving that there wasn't consent, because that's one of the elements of rape, right? So he has to show beyond a reasonable doubt that these women did not consent. And that's hard when you don't have proof of, blood under the fingernails, or, unfortunately in today's times, sometimes with the he said, she said, you want a little bit extra than just the she said. And that's why I think some of the evidence of the genital area showing that there was bruising for one of the victims is important corroboration that this was not consensual.
Right. Those are all such great points. And I think you hit the nail on the head. There's some common themes here from the prosecution, and we'll be back live in the courtroom. We have to go to a break, but stick with us. We are still live in the Winslow case, the prosecutor continuing his closing argument. I want to talk a little bit about this with Katherine. We've been sitting here, we've been listening. I think that the prosecutor has made the critical points. Right now, though, there's a lot of focus on this consent issue again. And now it's shifted a bit, right? It's about whether or not consent has been withdrawn. You can see here, the prosecutor is definitely anticipating where the defense is going to go and is trying to address it out front rather than on rebuttal. So what's your take on all of this, and has this been effective so far?
It's interesting. I didn't anticipate that there was going to be that much focus on the issue of consent. I guess it makes sense. Hopefully he's properly forecasting what their arguments are going to be. Otherwise, he would be highlighting some perceived vulnerabilities that the defense isn't even going to harbor on. But this idea of a revoked consent, I don't conflate it, but maybe the jury would. I consent to get in the vehicle, but then I don't consent to have sex with you. Obviously, in my mind, those are two very different things.
Right.
But he's worried that the jury is going to conflate the fact that the one witness said, yeah, sure, I'm going to come in your Hummer, but I still reserve the right to refuse sex. That seems pretty obvious to me, but he is making a point of that.
No, you're absolutely right. And I think that maybe he even needs to say that a little bit more directly to the jury, that, hey, look, just because you agree to go somewhere with somebody doesn't mean you're agreeing to take that next step. Although I will say that particular argument is a little bit more of a necessity for the prosecutor on their kidnapping charges,
Correct.
Right? Because there we have, you got into the car, and at some point you didn't want to be there anymore. That's a little more difficult.
Correct, that is. And also, you're absolutely right. That would be a necessity for him to actually prove beyond a reasonable doubt that that person was there against their will. So you can initially consent to go in the car, but when stuff gets really weird and you're uncomfortable and you want to leave, the minute you voice that, or the minute you feel unfree to leave, then you are being confined against your will. The other thing that I thought was important was that there is some issues of consent for the vaginal intercourse, but not for anal intercourse. And he had made that a point repeatedly, that there was absolutely no evidence that there was any consensual anal sex, and that should stand alone as a rape charge.
Yeah, certainly there's a lot of facts in this case because you have multiple victims, a lot of testimony to parse through. So it can be a lot for the jury to take in here on the close. The prosecutor definitely making the points, but we'll see what the defense has to say in response. All right, it looks like the prosecutor has concluded his opening statement here in the Winslow trial. We're waiting to see what the defense has next. But in the meantime, I want to talk to Katherine a little bit about this. All right, so the prosecution just brought up some really good points that would tend to show guilt. Let's talk a little bit about the Hummer. So Winslow's pulled over, he's asked to give a DNA swab, and then it looks like the following day, he's trying to sell his car. What do you make of that?
It's not a good look for Mr. Winslow. That to me shows what the legal term is the consciousness of guilt. Things that you do that are consistent with being guilty. I loved how the prosecutor said, this was the scene of the crime. This was literally like destroying the scene of the crime. And that's what he did by trying to get rid of the Hummer.
Right, and also we heard a little bit about that Strava account, just to note about how all of these apps, all of this social media is playing so much into criminal investigations and ultimately into trials. It's really interesting how something so innocuous can become such a critical piece of evidence. Anyway, we have to go to a break, but we will be back and continue to cover the Winslow case when we return. Stay tuned. Okay, so we heard the prosecutor making connections between victim Jane Doe 1, Jane Doe 2, and Jane Doe 4. Now, these are the 3 victims who are alleging rape. So I want to break this down with you, Katherine. So that was, I thought, pretty effective to talk about how there's similarities between Jane Doe 1 and Jane Doe 2. You're talking about 2 women, very vulnerable, one hitchhiking, the other homeless, but then also making that connection back to Jane Doe 4, which is something that occurred when she was 17 years old, when Winslow was 19 years old. And this is what we were talking about before, I think, the idea of that predisposition for this violent sexual behavior. What do you think about that, and what can we expect the defense to counter with?
I think logically, when you think about it, it makes sense that he has this predisposition to focus on people who are going to be low-hanging fruit, easy to abuse, less likely to be believed. There's a reason that he focused on someone who is very young and other people who are older and more transient, and that's so that he has this upper hand. It's classic predatory behavior, and that's really hard, I think, for the defense to rebut.
Yeah, certainly when you have multiple people with similar allegations, a la, let's think about even Bill Cosby, when you had other victims coming forward who permitted to testify at trial, many people think that that's one of the reasons that ultimately that trial resulted in conviction. So we'll see about that. But I also think the prosecutor focused on the violence, and that really sticks with you. It sticks with me as I sit here and listen to this trial, online. But when you're sitting in the jury box, it brings back those memories of the testimony of these women.
Right, and I think that there's a reason that he focused on the physical violence, and because he's telegraphed, by he I mean the prosecutor has telegraphed that he believes the vulnerability in his case is consent. And so to show the acts of physical violence and how that would obviously have led someone to feel forced into having that type of sexual behavior is important.
Yeah, certainly, along with those threats. So the prosecutor did a good job of getting the jury's focus on that. We're going to continue to go through more of the prosecution's closing argument, and we're going to transition into what we were just talking about, the force and the fear that the prosecution is focusing on in relation to the allegations of the victims. Take a listen. Okay, you saw it there on that slide, a focus on this force or fear element. We hear the prosecutor using the example of if you're brought out into a remote area, asking the jury to put themselves in the victim's shoes. You're brought out to this remote area and you know that you can't outrun your attacker. Is it reasonable not to do so? Katherine, so obviously we know that the prosecution has signaled, as you said, they're fearful about this consent aspect. Specifically, it appears with victims number 1, or Jane Doe 1 and Jane Doe 2. So they're talking about this fear. They're talking about the similar statements that were testified to as, I'm going to kill you if you don't do this, and this menacing and actual duress that the prosecutor mentioned in this statement. What do you think about all that?
Right. The more I think about it, I can understand where he feels vulnerable. Because, look, there's no weapon. I know that Jane Doe 1 said that she believed that he had a weapon, but we don't have proof of a weapon. We don't have many physical injuries to show that there was force. So the prosecutor is really trying to overcome his burden to show that there was no consent. And so laying down this menagerie of elements that made these women feel pressured is really important for the jury to understand when they go back there to deliberate.
Yeah, and I think you're absolutely right, because my guess is the defense is going to get out there and scream and yell, he didn't prove lack of consent beyond a reasonable doubt. But I have to say, they set the tone, the defense, in their opening, saying that there was a consensual sexual encounter, and that never presented any evidence. They didn't put their client on the stand, and there's nothing else in their case that would tend to show consent. So in my view, even though the burden is absolutely on the prosecution, the defense has a big problem there, because you don't want to say something in your opener that you can't deliver on.
And that's, I was wondering strategically why they were going to do that, because they must have known that they didn't want to put their client on the stand. It's usually prudent, especially under these circumstances, not to put him on the stand. And I think maybe they just wanted to plant that seed of doubt into the juror's mind. And when they watch the victims testify, ask themselves this question: what is more reasonable, that he was going to rape these women, or that they had some sort of tryst? And there's this implication that these are older, transient women, that they should have been sort of lucky to have this encounter, a sexual encounter with this famous younger man. I'm just forecasting that that's what they are going to do to show consent.
I think that's really interesting. Actually, it might have been the strategy from the beginning. Drop it in there in the open, let the victims testify, attack the credibility, and then later say the prosecution didn't fulfill their burden. Very good insight. Well, we do have to go to a break, but we will be back, and we are keeping our eye on all of the courtrooms. We're looking at Delgado, we're looking at Winslow, and we'll bring you back there live when we have a feed. Stay tuned.